All right, welcome back, everyone. We're diving into another landmark Supreme Court case today, one that's super important for criminal procedure, something I know you're all grappling with in your studies. We're talking about Rhode Island v. Innis.
Yeah, Innis, big one.
It all starts back in 1980, and at first glance, it seems like a pretty clear-cut Miranda violation, suspects' rights, questioning, the whole deal.
Right, the kind of case you think, oh, this is easy, open and shut.
But that's where Innis gets really interesting because it goes way beyond just the basics of Miranda and raises all these questions about what counts as interrogation under the Fifth Amendment.
Exactly, and that's why, even though it's from 1980, Innis is still cited all the time today. It really gets at the core of how police can interact with suspects, especially those who've invoked their right to remain silent, requested an attorney, all that.
Okay, so let's set the stage here. What were the basic facts of the case?
So we've got Mr. Innis. He's been arrested for murder, pretty serious stuff. The murder weapon, a sawed-off shotgun, hasn't been found yet. And crucially, Innis has been Mirandized multiple times, knows his rights, and has specifically asked for a lawyer.
Okay, so at this point, the cops shouldn't be trying to get any information out of him, right?
Exactly. He's invoked his right to counsel, meaning the questioning should stop. But here's where things take a turn. While Innis is being transported in a police car, he's in the back. Officers in the front, they start having a conversation.
Uh-oh, this sounds suspicious already.
Yeah, and this conversation isn't directed at Innis. They're not, like, grilling him with questions, but they're talking about something that relates to the case.
Okay, so what are they talking about?
They start discussing a nearby school for handicapped children. They're saying, how tragic it would be if one of those kids found the missing shotgun, maybe hurt themselves or someone else, a real accident waiting to happen.
Oh, wow. So they're not asking questions directly, but are they sort of trying to appeal to his conscience, maybe make him feel guilty about the potential danger if that weapon's out there?
That's the argument. And guess what? It works. Innis, hearing this from the back seat, he tells the officers to turn around. He says he'll show them where he hid the gun.
Wow. So even though they weren't technically interrogating him, the officers' conversation still elicited a response, and a pretty incriminating one at that.
Exactly. That's the crux of the issue in Innis. Remember, he had invoked his right to counsel. So the question for the Supreme Court was, did this conversation about the school children amount to interrogation under Miranda, even though it wasn't directed at Innis in the form of questions?
And what did the court ultimately decide?
It was a 6-3 decision, so pretty divided. The majority held that this wasn't interrogation under Miranda. They actually created a new test, what's known as the functional equivalent test for interrogation. Basically, they said police conduct is only considered interrogation under Miranda if the officers should have known that their words or actions were reasonably likely to get the suspect to respond, specifically in an incriminating way.
Okay, so it's not just about whether they directly asked him questions, but about whether a reasonable cop would know in their little chat about the school kids might make him spill the beans.
Right. And in this specific case, the majority said there's no evidence the officers were intentionally trying to elicit a response from Innis. They thought, hey, we're just talking amongst ourselves.
So they were just having a casual conversation, or at least that's what they claimed. But the fact that Innis overheard and reacted changes everything.
Exactly. And that's what makes Innis so fascinating and frankly kind of messy, because it introduces this idea that even seemingly indirect police conduct can be considered interrogation under the right circumstances. It's not just about asking direct questions anymore.
Okay, so we've got the majority opinion, but it wasn't unanimous, right? There were dissenting opinions as well.
Oh, absolutely. Some very strong dissents that raise some really important points about the potential for police manipulation and the whole purpose of Miranda protections in the first place.
Okay, well, let's hear those dissenting viewpoints because I have a feeling they're going to be crucial for anyone studying criminal procedure.
All right, so we're back, diving deeper into Rhode Island v. Innis, and we left off talking about those dissenting opinions, which, they can be just as important as the majority opinion for really understanding how a legal principle develops over time.
Absolutely. I mean, just because the majority ruled one way doesn't mean everyone agreed with their logic or how the functional equivalent test might play out in practice.
Exactly. And in Innis, those dissents bring up some really important points that I think every law student should know because they highlight those potential problems with letting police, get a little creative with their tactics.
So let's unpack some of those dissenting viewpoints then. What did those justices who disagreed with the majority have to say?
Well, Justice Marshall, he had a really powerful dissent. He argued that Pretty much anyone would be affected by this kind of appeal to conscience. The idea of a kid finding a dangerous weapon, even if the cops didn't specifically know about Innis's individual sensitivities or anything.
So he's saying it doesn't matter if the police knew Innis specifically would be susceptible to that kind of emotional pressure. It's more about the tactic itself, the fact that it would likely work on just about anyone.
Exactly. He was concerned that the majority's ruling would basically give police free rein to use these subtle forms of psychological manipulation without technically violating Miranda, which was a huge concern, protecting those core constitutional rights.
Right, because if the police can just find ways to, like, push buttons without technically asking questions,
Yeah.
it kind of undermines the whole point of having Miranda protections in the first place.
Totally. And then you have Justice Stevens. He had a different but equally important dissent. He was more cynical, I guess you could say. He argued that this ruling would basically give police a loophole, like a way to get around Miranda without really getting around it.
So he was worried about the slippery slope argument, right?
Right.
Like, if this is allowed, what else might police start doing to elicit confessions without technically asking direct questions? It opens a can of worms.
Exactly. He was basically saying this could lead to all sorts of creative tactics from law enforcement, blurring the lines of what's acceptable under Miranda even further. And you can see how that would be a huge concern for defense attorneys, even today, trying to ensure their clients' rights are being protected.
Yeah, Innis really gets to the heart of that tension, that balance between giving police the tools to do their job and protecting individuals from coercion or unfair tactics.
It definitely does. And, we've been focusing a lot on those dissenting opinions, but even the justices who agreed with the outcome in Innis, those who are in the majority, they didn't all agree on the reasoning behind it.
Oh, interesting. So even within the majority, there were nuances in how they interpreted the case
Yeah.
and the functional equivalent test.
Yeah, like Chief Justice Berger, who wrote the main opinion for the majority, he actually seemed to suggest that the whole concept of Miranda was already a pretty settled law, that police had adapted to it. He almost seemed to say, we don't need to make this any more complicated than it needs to be.
So while he sided with the majority in this case, he wasn't necessarily a champion for expanding the scope of Miranda rights beyond what was already established.
Exactly. It goes to show that even within a single ruling, there can be these subtle differences in judicial philosophy, those underlying beliefs about how the law should work and how it should be interpreted. And those differences can have a big impact on how these principles play out in future cases.
It's almost like those concurring opinions, even if they agree with the outcome, can kind of foreshadow how a particular legal issue might evolve over time.
Yeah, it's like planting seeds, right? Ideas that might not be fully developed yet, but that could influence future decisions down the line. It's why those concurrences are always worth paying attention to. They can offer some really valuable insights.
Absolutely.
Yeah.
So even though we don't have time to go into detail about every single concurrence in Innis, I think it's important for our listener to know that they're out there and that they could offer even more nuanced perspectives on the court's decision.
Totally. It's always worth digging a little deeper, going beyond just the black and white of the holding and really wrestling with the reasoning behind it. That's how you develop a deeper understanding of the law and how it works.
Okay, so we've got a pretty good grasp on the majority opinion, those crucial dissenting viewpoints, and even some insights into the concurrences. But now I want to shift gears a bit and talk about how all of this, the Innis ruling, the functional equivalent test, all that, how it actually plays out in real-world scenarios.
Oh, yeah, absolutely. I mean, it's one thing to learn about these legal concepts in class, but it's another thing entirely to see how they're applied in actual cases, in the courtroom with real people's lives on the line.
Exactly, and that's what our listener is ultimately preparing for, right? To be able to use this knowledge effectively as they navigate the legal system.
Right. So thinking about Innis, and especially that functional equivalent test, it can be pretty tricky, right? It's not like a clear-cut rule. It requires a lot of interpretation and analysis on a case-by-case basis.
Yeah, it's not just a simple checklist. There's a lot of gray area. And that's where things can get really interesting and challenging for lawyers on both sides of the issue.
Absolutely. So let's say our listener is a defense attorney, right? They've got a client facing charges, and there's a confession involved, but they're kind of suspicious about how that confession was obtained. Maybe they think the police might have pushed the limits of what's allowed under Innis.
Okay, so we're not just studying Innis now. We're actually putting ourselves in the shoes of a lawyer who needs to use this case to protect their client's rights. Love it. So what's the first thing this lawyer should be doing? Where do they even begin?
Okay, so we're back, wrapping up our deep dive into Rhode Island v. Innis. We've gone through pretty much everything, the facts, the holding, all the different opinions, and even tackled that tricky functional equivalent test. But like we always say,
We want to leave our listeners with something to ponder, something that connects this 1980 case to the realities of criminal justice today.
right, because that's how you make this stuff stick, you know? Seeing how these legal concepts actually play out in those real life situations, the investigations, the courtrooms, the whole thing.
Exactly. So, for our last segment here, let's imagine our listener, IS, the defense attorney, the one who's got a client facing serious charges. And there's a confession involved, but something about it just seems off. Like maybe the police pushed the limits of what Innis allows, those gray areas we've been talking about.
Okay, I like it. We're not just studying Innis, we're strategizing, thinking about how a lawyer would actually USE this case in their work. So, first things first, what's our lawyer looking for? Where do they even begin?
I'd say start by analyzing every single detail of how the police interacted with the suspect before that concession was made. Were there any words, any actions, even subtle ones, that could be seen as the functional equivalent of interrogation under Innis? That's the key.
Right, and it's so important to remember that interrogation isn't just about those straightforward questions. It's about any police tactic that a reasonable person would think is designed to get the suspect talking, especially after they've invoked their right to counsel, asked for a lawyer.
So our lawyer needs to become a detective themselves, right? Digging into all the evidence, the interrogation transcripts, police reports, witness statements, anything that shows the full picture of what happened.
Exactly. It's like piecing together a puzzle, trying to figure out if those subtle forms of pressure were used. And there are definitely some red flags our lawyers should be watching out for, like how long was the interrogation itself? Was the suspect deprived of sleep, food, things that can make them more likely to break under pressure?
Right, because all of that context matters. It helps determine whether a confession was truly voluntary or if it was coerced. Those details can be crucial.
Absolutely. And then think about the setting where the interrogation took place. Was it a small, cramped room, uncomfortable, maybe even designed to ramp up the anxiety and make the suspect feel trapped? All of that can play a role in creating a coercive environment.
It's wild to think about. But yeah, even the physical surroundings can influence a suspect's state of mind and make them more vulnerable.
Totally.
Hmm.
And of course, the officer's behavior is absolutely key. Were they being aggressive, making threats, or maybe offering promises, things that could induce a false confession? Did they lie to the suspect about the evidence, try to trick them into thinking they had no choice but to confess?
Now we're back to those functional equivalent scenarios we talked about earlier, right? Like bringing the suspect's child into the interrogation room, or maybe staging a fake lineup to make them doubt their own memories. Stuff that isn't direct questioning, but could still be super manipulative.
Exactly. Those are some extreme examples, but there are tons of subtler tactics that police might use. A good defense attorney needs to be aware of all of them, understand the psychology behind these interrogations.
Okay, so let's say our lawyer does find some red flags, some evidence that the confession might not have been totally voluntary, that maybe the police crossed the line under Innis. What's the next step? What can they do with that information?
Okay, so now they've got to build their case, right? They need to put together a rock-solid legal argument challenging the admissibility of that confession in court. They need to convince the judge that whatever the police did, it went beyond the bounds of what Innis allows, that it was essentially interrogation disguised as something else, meaning it violated the suspect's Miranda rights.
So they're using Innis as their weapon, showing how the functional equivalent test applies to the specific facts of their client's case. That's how they fight back against potentially coercive police practices.
Exactly. It's about connecting the dots, showing the intent behind the police conduct, proving that their goal was to get a confession, regardless of whether they technically asked any direct questions. And if the lawyer can make that argument effectively, well, that confession could be thrown out entirely, which is huge for the defense.
Wow, that's a game changer. It really shows how important Innis is, how it gives defense attorneys a tool to fight for their clients' rights, to ensure that confessions are truly voluntary and not the result of some sneaky tactic.
It absolutely does. Innis is a vital safeguard for those Fifth Amendment protections we've been talking about, making sure that suspects aren't tricked or pressured into incriminating themselves. It's about fairness, ensuring everyone gets a fair shake in the legal system.
This whole deep dive into Rhode Island v. Innis has been honestly eye-opening. It's amazing how much depth there is to this one case and how relevant it remains even decades later, in the world of criminal justice today.
It's a classic for a reason, you know? And for anyone studying criminal procedure, it's not just about memorizing the facts of the case. It's about understanding the principles behind it, how it shapes the way we think about police conduct, about protecting the rights of those accused of crimes, even if they're guilty. Everyone deserves a fair chance.
I think you hit the nail on the head. It's about more than just the black and white of the law. It's about the human element at the heart of it all, something we've tried to emphasize throughout this whole episode.
Couldn't agree more. Behind every case, every legal principle, there are real people whose lives are being affected by these decisions, and we can't forget that.
So to our listener, as you continue your studies, as you prepare to step into the courtroom, to become those defenders of justice, remember that human element. You're not just dealing with abstract concepts, you're dealing with people's lives, their freedom, their futures. That's a huge responsibility, and it's one we should all take seriously.
Beautifully said. It's about finding that balance, between upholding the law and ensuring that justice is served, that everyone's rights are protected. That's what it's all about.
Couldn't have said it better myself.
Mhm.
And on that note, I think it's time to wrap up this deep dive into Rhode Island v. Innis. Thanks for joining us today, everyone, and we'll catch you next time for another fascinating journey through the legal world. Until then, keep those brains engaged, and we'll see you soon.